Oh, yeah, 5 minutes is. All right, well, okay, welcome to Senate Institutions. It is Wednesday, March 12th, and we are discussing S71, which is an act relating to consumer data privacy and online surveillance. And I just want to let folks know who might be listening, and obviously folks in the room, is that S93 is a similar bill, and we will likely be working with both bills. And we started talking about S93. We'll need to do a walkthrough on it, but that's part of our conversation.
Are we officially getting this 93?
We've, yes, but we haven't yet. And I'm gonna say kind of, but, yeah, it won't have to go through the process. And Senator Chittenden is well aware of this and approves it and, didn't need to formally present it to us. Okay, so we have a few witnesses today to talk about data privacy and our efforts to improve it in Vermont. And our first witness is Matt Schwartz, policy analyst from Consumer Reports. And thank you very much. Thanks for coming.
Thank you.
Introduce yourself.
Chair, members of the committee, thank you for allowing me to testify. Thank you for your attention to the issue of data privacy. I'm Matt Schwartz. I'm a policy analyst from Consumer Reports based in Washington, D.C. We strongly support S71. SCR is an independent, nonprofit, and nonpartisan organization. Work with consumers to create a fair and just marketplace. We have 6 million members spread across every state, including Vermont. We've advocated at the federal and state levels for the introduction and passage of comprehensive privacy. We've worked with lawmakers and advocates in Vermont and other states to advance legislation that's as workable and as protective of consumers as possible. As you've surely heard from many others, Congress has tried and failed to pass a privacy law for years now. So it's fallen to states to step up and try and protect their constituents as well as they can. Vermont came very close to enacting the privacy legislation protecting consumers and ensuring clarity and predictability for Vermont businesses last year. We hope that this year a strong bill can make it over the finish line as well. And as you also might be aware, big tech companies have made the rounds kind of across the states to try and pass their favorite model of privacy legislation in lieu of stronger protections that we can meaningfully change business practices to address harms faced by consumers. That's why we're so glad to see that this committee is considering S71 would provide Vermonters with more control over how their personal information is collected and used. And we support it for 3 main reasons. So first, the bill has strong data minimization provisions. We heard about this a bit yesterday. Data minimization is the idea that companies should only collect and use data that's necessary to provide the service that consumers ask for. So my weather application needs my location data, obviously, to give me an accurate forecast, but doesn't need to then sell my location data to other businesses or data brokers for unrelated purposes. So S71 would ensure that unnecessary uses of data are blocked by default and wouldn't require the consumer to make any choices such as opting in or opting out to protect themselves. And I thought the lawyer, working with the chamber yesterday had a really interesting point. And he was talking about his duty of confidentiality to his clients and that he could lose his license if he misuses their personal data. I think that type of baseline responsibility to protect consumers, protect consumer data, that's exactly what a privacy law should be creating and what data minimization in S71 would do. We think companies should be responsible for protecting consumers' personal data beyond simply giving them an opportunity to opt out of those kind of unwanted, unexpected secondary uses of data. So under the standard, while the most invasive forms of tracking and profiling consumers across contexts would be banned, businesses would still be able to provide personalized recommendations, use their own data for targeted marketing, and even engage in targeted advertising so long as they abide by opt-out. So we think that that minimization, both benefits consumers, obviously, but businesses as well by creating real trust that consumers can use a business's products or services without fear of the data being used against them. That's a key difference, we think, between S71 and S93, which we were also considering. Second, S71 creates heightened protections for sensitive data, including an outright ban on the sale of sensitive data like our cell phone location data, religious and political beliefs, and information collected from minors. So, unfortunately, there is a multi-billion-dollar industry centered on collecting and selling people sensitive information, often collected from their mobile devices. That data is amassed by data brokers, which are entities that essentially aggregate extensive files on virtually every single American that include thousands of data points about them, including information about your behavior, your precise geolocation throughout the day, your health data, information about minors, and more. And that data is kind of routinely used for purposes against the consumer's interest, including to perpetuate financial fraud, to stalk individuals in some cases, and increasingly to price insurance, all based off of information that you didn't even know that you were sharing in the first place. So under S71, companies could still collect and use sensitive data to provide the products and services that consumers expect. But we don't think our sensitive information should be sold for unexpected purposes. We strongly urge the committee to retain that protection. That's what's done in the American law. Finally, we note that the bill would be currently enforced in part by a private right of action. We believe that is appropriate to help, incentivize businesses to comply. There's 13 active state privacy laws right now, and they're all enforced by AGs. That's true. So there's only been a handful of public enforcement actions to date. And at the same time, you don't need to look very far to find really obvious violations of those existing privacy laws. I saw 2 separate privacy compliance websites had a report that showed that they found that more than 70% of top websites were not compliant with opt-out provisions under existing laws. We know that Vermont businesses want to do right by their consumers, but we also know that a strong and effective enforcement mechanism is needed to ensure that the data of Vermont consumers is protected. We do think that some form of the PRA is the best way to get there. We are more than willing to be flexible about what that looks like in practice, including, yesterday folks were talking about frivolous lawsuits. Happy to talk about guardrails for that. But I think leaving the laws fully under the purview of the AG's office has not been a successful strategy so far in other states. So we recognize there's another bill, S93, that's currently being considered as well as an alternative. It's being referred to as the New England model. I think the committee should know a few key things about that idea. First, the Connecticut law that kind of serves as the basis for this so-called model is continually being updated. It's already been updated twice, and now they're considering another round of amendments based off of feedback from an AG report actually in Connecticut that highlighted the numerous loopholes in that law that was making it very hard for them to enforce it. And then second, half of the New England states, Vermont, Maine, Massachusetts haven't even passed their privacy law. And indeed are all kind of actively considering privacy bills that are stronger than the Connecticut law. We do think interoperability with other states is important. And we know that S71 does share much of its DNA with the Connecticut model. But I don't think those other states intended for their laws to be the ceiling of what a privacy law could be. And so we urge you to center the needs of Vermonters and pass a strong bill. Thanks again for inviting me. I'm happy to answer any questions you have.
Great. So first, if you could please provide us written testimony,
Will do.
that would be great. Do either of you have any questions? So I have a couple questions. The frivolous lawsuits, you said you had information on how to
Yeah,
minimize that. That's been really the main concern that I've heard from folks.
Yeah, I think there's probably some language that we could, work through with the components of the bill, if that's the key kind of concern to try and root that out. That really is, an issue we're trying to address.
Yeah, that is a concern. And then, you mentioned a report. What was it? Oh, the compliance report? So
Yeah,
hopefully you'll send a written copy of that.
Yes,
I'm
I can.
interested in seeing that.
I will put that in the written testimony, make sure that's highlighted for you all as
Okay.
well.
Okay, great. All right. Well, thank you very much.
Thank you. Appreciate
Okay, our next witness is Chris Delia. So you can just introduce yourself. We remember you?
Hi. Unfortunately, you do.
No.
Good afternoon, Madam Chair, Chris Delia, President of the Vermont Bankers Association, the afternoon committee members. Appreciate the opportunity to come in and talk with you on this particular bill, which is obviously much broader in scope than the one that you folks just did on the floor. I'd like to begin by saying we absolutely want to see a privacy bill pass in Vermont. It is so important for our customers to have that privacy bill in place because often we see the negative outcomes of their privacy being compromised, and then it therefore leads to some financial losses over time. So we want to see a bill pass. I was reminded yesterday listening to the testimony, we've been working on this since 2018.
Mhm.
It's been a long time. These are not easy discussions to have. And I'm hoping that, and I was glad to hear that you'll be getting 93 to work on as well. I'm hoping that we can find a path forward that takes some step in putting privacy regulations in our statutes. That is vitally important. I think we learned lessons from last year's outcome. And hopefully we don't see ourselves in those positions again. This is, in my mind, the type of issue that is going to come up on a regular basis. Worked on many pieces of legislation over the years that continually come up year after year or every other year because circumstances change in the marketplace. So it's not the first bite at the apple. There will be multiple bites that I think we'll be able to address over time. So yeah, I want to just take a quick moment to reacquaint you with some of the conversations we had on the previous bill with S69. We are a leader in the marketplace when it comes to protecting consumer data. When I look at this bill, we fall under definitions of a data collector and a data processor, and I'll explain to you why. So, if you will, federal banking regulations require us to have certain policies and procedures in place when it comes to engaging with consumers. So, for example, when I walk into the bank needs to know that I am in fact Chris Delia. So the first thing that they do under the Bank Secrecy Act, which passed after 9/11, was to create and implement customer identification procedures. So this collects the type of data that you're thinking about in this bill: name, address, social security number, driver's license, could be other account information. All of that helps to create the picture for the institution that, again, I am in fact Chris Delia. Because we collect that data, Congress and our regulators, as well as the regulators in Vermont and the legislature, recognize that we need to secure and protect that data. We need to maintain it, and at the appropriate time, destroy that data. So I'm going to go through some of the regulations in brief that we have to comply with. So the first one would be the Gramm-Leach-Bliley Act and Vermont's privacy regulation, which is unique to Vermont. Title V of GLBA requires the FTC, along with the federal banking agencies and other regulators, to issue regulations ensuring that financial institutions protect the privacy of consumers' personal information. Such institutions must develop and give notice of their privacy policies to their own customers at least annually and before disclosing any consumer personal information to an unaffiliated third party, and must give notice and an opportunity for that consumer to opt out. Vermont wasn't comfortable with that. Vermont went further, and in 2000, and it was updated in 2018, this legislative body, or your predecessors, and the folks at the Department of Financial Regulation worked on a unique privacy regulation for financial institutions, healthcare providers, and others that are regulated by the Department of Financial Regulation. It includes, aside from the purpose and scope of the regulation, opt-in requirements, which means you are already protected. We can't do anything with your data unless you opt in and allow us to do something with it. The only exemptions, if you will, are spelled out in that privacy rule, as well as Title 8, Chapter 200, which are legislative policies that were adopted. So an example would be if the Department of Children and Families were working on a deadbeat dad or parent case, they could approach a financial institution to seek to understand what capacity you have within your accounts to cover childcare. Same thing would be true of your tax department. Same thing would be true of sharing information with the Department of Financial Regulation. So very clear exemptions that are spelled out in either the privacy regulation in Vermont or Chapter 200. So banks must follow those federal and state regulations, but we also have what are called record retention regulations. And again, that's at the federal level and at the state level. So for example, we need to hold on to your social security number for 7 years. We need to hold on to bank statements for 3 years. And there's a long list of either documentation or information that has timeframes associated with it, either at the state level or the federal level. So you can imagine with these regulations in place, our industry is examined on either a 12, 18, or 20-month time period, 24-month time period, excuse me, for compliance with those regulations. Are we in fact meeting the letter of the law and what's been developed subsequently by those regulators as it applies to the institutions? And if not, we are held accountable by those regulators, which would include the Department of Financial Regulation, Federal Deposit Insurance Corporation, Office of Comptroller of the Currency, the Federal Reserve, and even the CFPB, which is still very much in existence. It'll be under a different structure currently, but still in existence. So when it comes to this bill, we greatly appreciate the language that you have in there that deals with the exemptions for the financial service industry. That's very important to us because we already have bodies of regulation that we need to adhere to. And this would create confusion as an overlay with those existing regulations. So with that in mind, I have, as I mentioned to you earlier, Madam Chair, 5 word changes that I will give you in an email as well as your legislative counsel, but I can highlight them for you right now.
Please.
So on page 23, line 16, parentheses 13, this is the one that you folks adopted in S69, but it's missing 2 words, and the 2 words are or data. So we would ask you to consider putting that in, or those words in that particular section. You know, on page 23, line 18, parentheses 14, I believe this is an oversight, but you have a definition of independent trust company in the bill, but it is not included in the exemption language in parentheses 14 on page 23, which is where it was in H121 last year. And then the final thing is just a correction in a number. Again, on page 23, line 20, Ledge Council had 18 USC 1843K, and the correct citation would be 12 instead of 18.
All right, since he's not here, tell me that again, please.
It-
No, he doesn't have to watch I mean,
Oh, that's
he'll
okay.
want to watch it.
You asked me for an email, so
Yeah.
I'm going to send you an
Okay.
email.
Yeah,
And I already spoke with Rick and told him
Oh,
to
good.
send him an email as well,
Okay,
just to get the correct citation.
and I'm sorry, say, what is that exactly?
So it's 12 USC 1843K. That is the Bank Holding Company Act. And why that's important is it clearly identifies what are the allowable services under financial institutions.
Okay. Thank you.
And that was talked about last year because it was trying to narrow the scope of who this bill would apply to.
Okay.
So
So I'm sorry, go ahead.
no, so just in closing, again, I appreciate the opportunity. I appreciate what language you have in the bill. Would ask you to consider those changes and really hope that you can find a path forward to get a privacy bill in statute in Vermont.
Thank you. I hope we can find a way forward also. Frustration for me is that we have potential harms, but potential harms in the future, but demonstrated harms now. So balancing that
Absolutely.
is pretty hard.
Yep.
And we need to address the harms that we are experiencing now.
Yep.
So,
Like I said, these have been difficult conversations for quite some time.
yes, but we need to get past the conversation
You're
and start
Absolutely correct.
acting. All right. Well,
Yes,
thank
ma'am.
you for being here.
Thank you. I appreciate it.
And, oh, do you have any questions? Okay. Okay. Thank you.
Thank you.
And actually, I'm sorry, I do have another question.
Sure.
Just, a few months ago, you had a legislative delegation meeting and we talked about fraud and,
Yes.
your customers, just really any bank customers.
Sure.
Do you keep records about fraud? Like, is it getting bigger? Is it,
It's gotten much worse over the last 18 months.
can you, that's important.
I can share with you. So, banks are required under regulation to, file what's called a suspicious activity report for suspicious transactions and transactions over $10,000. Unfortunately, I can't share any of that with you because they are confidential documents that go up to the Financial Crimes Network Enforcement Network at the federal level. There are many times when we scratch our heads wondering what the heck happened, what's happening for their investigations, what were the outcomes. But what we've seen is an increase in the scams that you may have just read about regarding the Canadians that were arrested.
Mhm.
So it's these scams that prey on the individuals who are, the romance scams or the, grandson scams or the granddaughter scams, the Microsoft scam, whatever it may be. And what we typically see is somebody coming into the bank and wanting to conduct an unusual transaction, take money out of their account. And that begins a dialogue with the customer service representative, the teller, and even with the fraud division within the financial institutions to better understand what is happening. And there are many times when those conversations are successful. And then there are times when at the end of the day, it is the customer's money. And they truly believe that they are involved with something good. And they take those funds and they will, as I have heard in your county to the west of you in Bennington, there are mules that will come into the county every 3 or 4 months just to pick up cash from victims and transport that cash over the border to Canada. There are victims, one that I'm aware of in your neck of the woods, that used an crypto kiosk machine in Keene, New Hampshire to what they thought was conduct a transaction to correct their problem account and lost $9,000. So it has increased dramatically. We are constantly educating our bank folks. We use things like AARP's training program to do that. We use social media, flyers, whatever it may be. But it's still happening very much in the marketplace
And increasing.
and increasing. Yes, ma'am.
All right, here's one of our Bennington,
Fuel will be,
well, we just heard about issues in Bennington County, which I would expect that law enforcement has been called on.
So we have a great working relationship with Secret Service, FBI, Homeland Security, and local law enforcement. Here are some of the challenges for local law enforcement: lack of resources and overstretched with the challenges they have to deal with. So financial crimes sometimes don't rise to the level that we would like, and understandable given the circumstances that local law enforcement has to deal with. FBI, Secret Service, are great to work with, but their resources are limited. We're fearful they may become even more limited with changes that are happening at the federal level. I will say the video that Secret Service showed us on the mule showing up to the house was unbelievable. Just a gentleman drives up in a car, knocks on the front door. The person who lives there gave them $10,000 in cash. And the mule proceeded to walk away from the house. Unfortunately, somehow they got away from Secret Service. They didn't tackle him hard enough and he got away. But that is happening in places like Bennington and other locations. They're very sophisticated. They will line people up and the mules will come in for a week at a time. They'll go away for 3, 4, 5, 6 months and then come back because they've lined more people up with the same scheme.
Okay. So I'm presuming that somebody is working on it.
Oh, there's a lot of, there are a lot of folks who are working on it, absolutely.
So if there's legislation necessary, that won't be that will be this committee.
Unfortunately, legislation is not gonna solve the problem.
Okay.
What's really gonna solve the problem is education in the marketplace, and I'm a believer, and I've said this to folks, you gotta hit people over the head 5, 6, 7 times before they begin to think about, oh yes, this is a real problem. So whether it's us, whether it's AARP, whether it's other groups that are doing education in the marketplace, which we all are, there's no legislation that you're going to pass right now that I can think of that's going to stop a mule from coming.
Right. All right. Well, thank you. That's good to know. And if you could please put that in your testimony too, if you don't mind.
Sure, absolutely.
Okay. Thank you.
Thank you.
So Zachary, are you ready?
I'm ready.
Thank you. From VPIRG.
From VPIRG. You have written testimony that's been submitted on the website.
Great.
Good afternoon. For the record, my name is Zachary Tominelli, and I am the Consumer Protection Advocate for VPIRG, the Vermont Public Interest Research Group. VPIRG, we've been around for more than 50 years. We've been advocating for the public interest in policy debates concerning the environment, healthcare, democracy, and notably for this issue, consumer protection. So thank you for this opportunity to share our thoughts on S71. I won't hide the ball here. Matt stole my thunder a little bit, and I'll be emphasizing a lot of the same points. But I think that's okay because hopefully hearing from 2 different consumer groups emphasizing the same points will maybe make clear that these are the issues that we think are most important to consumers, when considering this bill. So I just want to start by thanking the committee for working on this important issue and note that VPIRG is strongly supportive of the comprehensive consumer privacy reforms that are contained in S71. Vermont has already taken some pretty great strides to better protect consumer-sensitive information in recent years. VPIRG supported and was glad to see the data broker registry law that you heard about yesterday. That was passed in 2018. We also supported the student online privacy law that was enacted in 2020. But we have, as a state, stopped short of enacting a more comprehensive data privacy law. And we think that that's necessary for giving Vermont consumers, the broadest protections possible. You heard yesterday, 19 other states have enacted some kind of comprehensive data privacy legislation. And while these laws vary in the level of protections that they actually provide consumers, the fact that 19 states, and these are, I would say a diverse group of states, Western states, Eastern states, blue states, red states, if you want to, classify things that way. But the point is, states are moving forward on this, and it's not really a partisan issue. I think people recognize that, our data and it's getting out there and it's a little bit out of control and we need to do something, particularly with nothing happening on the federal level. So we think this legislation, it's essential for our state to keep up with the rapidly changing data landscape. And our reason for supporting this is grounded in 3 essential principles. And I do want to talk about, why, because when this has come up the last couple of years, and we've, advocated for this, sometimes I feel like I've heard, well, what are the harms? Like, what is the issue that we're trying to solve here? Like, I get in a general sense, like, oh, we want our information to be private, but, data breaches, they're still going to happen. This bill, won't stop data breaches. Or, why is it a big deal, for instance, if, a certain company knows that I really like to buy blue jackets? Like, is that really a problem? And that in and of itself isn't really a problem, but there are real potential harms here. And notably, we think about something like a data breach. So for instance, in 2021, T-Mobile had a massive data breach of both customers and potential customers. And they lost the information, names, addresses, contact information, but also social security numbers. And it brings the question, notice I said customers and potential customers. Why did T-Mobile have the social security numbers of potential customers? Well, under a data minimization standard, which we'll talk about now, they wouldn't have that. That's unnecessary to, conduct to provide the good or service that they're trying to provide. So while this bill won't necessarily stop data breaches, if we are able to limit the information that is proliferating out there, getting out there, we can stop those potential harms. I mean, thinking of it that way, you have the potential to prevent a future Vermonter from having their identity stolen, from having and realizing financial harm. Like, you have that awesome opportunity here with this bill. And the other issue is that our current laws leave significant gaps, particularly at the federal level. It's not as if we don't have any privacy laws. People are, I think, somewhat familiar with the alphabet soup of laws that we have, whether it's HIPAA, FERPA, et cetera. But this is confusing for consumers to sort of navigate. I mean, to the extent that people are familiar with HIPAA, I think if you ask the vast majority of consumers, they would say something along the lines of, well, that protects my health data, which is true in a broad sense, but, it only applies to health data that is held by, certain covered entities. You heard the example yesterday. If I go on WebMD and I'm searching symptoms and Facebook or Meta has a pixel on WebMD and they're gathering that data, they may be gathering health data by me. That's not protected by HIPAA. Right now, they can do whatever they want with that information or that data. So we think this is confusing for consumers to navigate. They don't understand what is or isn't protected, hence the need for state-level comprehensive data privacy. So it's our position that we should enact policies that treat consumer data privacy as a default, and as much as possible, remove the onus from Vermonters exercising privacy rights through confusing opt-ins, opt-outs, and puts the responsibility on data collectors to respect Vermonters' data privacy. We think S71 does this in a lot of key ways, and in ways that are different than a lot of the state-level privacy laws that have been enacted to date, also contrasting with S93. So we do think S71 offers more consumer protections than the model that is contemplated in S93. And so I'm just going to talk about 3 key ways that we think it's different, and honestly the most important ways. So the first, you've heard this before, but I will hammer it home: the meaningful data minimization standard. This is sort of the whole ballgame. Data minimization, it is the common sense principle that companies only collect and use the data that is reasonably necessary to deliver the service a consumer is expecting to get, nothing more. No secretive data harvesting, no selling our information to unrelated third parties. So contrast this with the data minimization standards that are in other states, that is in S93, which, and it's, honestly a few different words, but they're important words. Those data minimization standards only require companies to limit their data collection and usage to that which they disclose, that what they put in a disclosure. This is arguably worse for consumers than maybe even an opt-in, opt-out type model, because it basically allows current data practices to go unchanged, and it in some ways incentivizes companies to actually make these privacy disclosures more cumbersome, to dissuade consumers from reading, going through them, and finding out how their data is actually being used. So S71 maintains a meaningful data minimization standard. It's much more in line with what Maryland has enacted. And we think that that's best for consumers. Also, the ban on the sale of sensitive data. Some information is far too sensitive to risk falling into the hands of others. No app should be allowed to sell our location data. No doctor's check-in software should be allowed to sell our appointment information. No student learning platform should be allowed to sell our children's data. All sales of these types of data should be against the law. And then finally, strong enforcement via, in the case of S71, a very narrow private right of action for violations. So we've seen time and again that privacy laws require robust enforcement to be maximally effective. We believe the inclusion of a private right of action ensures robust enforcement. We know the resources of the Attorney General's office are not limitless. They may only be able to bring action for a handful of violations over the course of a year. So private right of actions ensure compliance and provide consumers with recourse when their privacy rights have been violated. It is notable the way that the drafters of S71 have clearly sought to be responsive to the concerns raised about the private right of action. It's very narrowly tailored, so it's only applicable to data brokers and large data holders. It's only for violations of the sensitive data portions of the bill, and it's only after the Attorney General has reviewed the claims to determine that they're not frivolous. It's also worth noting that a private right of action is included in Vermont's underlying Consumer Protection Act. This came up yesterday. And if the committee wanted to go that way and just simply reference, the underlying Consumer Protection Act, I think we would be open to that as well. And the reason I bring this up is the controversy around, the underlying Consumer Protection Act, right, or private right of action is very recent within the past year. It is extraordinarily commonplace to include that in consumer protection laws. So you can review consumer protection laws that have been enacted by this body over the years, including that Student Online Privacy Act that I referenced. That includes reference to the Consumer Protection Act, includes a private right of action. Vermont has a consumer protection law around automatic renewal of contracts. So when you sign up for a subscription service that renews every year, something like a Netflix or SiriusXM Radio, or maybe like a software service for your company, they have to provide you certain notice 70 days out from when it's going to be automatically renewed, and different ways that you can opt out of that renewal process. That includes a private right of action via the Consumer Protection Act. We passed a law reining in the rent-to-own industry, making it so that they can't charge exorbitant amounts over time to people trying to rent-to-own appliances. That includes a private right of action via the Consumer Protection Act. And I have not heard of frivolous lawsuits coming via the Consumer Protection Act. You heard yesterday that through the Consumer Protection Act, there's maybe been 10 brought. I don't know if that number is exactly accurate. So the idea that just including a private right of action means that there will be de facto countless lawsuits, it's not played out by history or by what we've seen. So I think enough said on that. In summary, I do and VPIR greatly appreciates the committee's time and attention on this. We do strongly support S71 as a truly consumer protected data privacy model. Urge you to advance the bill, and thank you for the opportunity to present this testimony.
Thank you. That's very helpful. Any questions?
And it sounds like you don't support much that doesn't have right to private action. Why would that be?
I wouldn't say I don't. I mean, there are, even without the private right of action.
But why would it be? Why would you like the private right of action?
Because
the lawsuits or?
No, and not that I'm necessarily a fan of lawsuits, but I think it provides the consumer the ability to directly hold those who violate their rights.
But what about outside firms, as far as people in California want to sue or Nevada want to sue or anything like that? It opens up for that too, right? It makes it more easier to sue and all that.
Well, it
makes it money for trial lawyers and stuff.
That's not my motivation. I mean, I just believe that it's a right that we have been trying in the Consumer Protection Act. And that's, I guess, one last point on this. It's been kind of framed as no state to date has put a private right of action in their comprehensive privacy law. And I would submit to you, because most of those states that have passed comprehensive privacy laws have an underlying Consumer Protection Act that has a private right of action. So I would actually frame it as, in every state that has passed a consumer protection law to date, industry has successfully lobbied to have those legislatures actually remove the private right of action from those laws. So
it doesn't seem to be that way, though. It seems to be that everybody that comes in here that's got an attorney base, and especially the ones that represent people from outside of our state, really want that private right of action. They really just want to be able to sue everybody instead of just kind of having a good conversation with them. I don't understand it.
I'm not an attorney. I'm not from out of state, but I think
I think you represent a lot of people that are, and it's just kind of disturbing that everybody that comes in here representing out of state interests just really want to sue the people of Vermont. I have a problem with that.
I don't think that's fair.
Well, I think it's
VPIR is a Vermont. It's Vermont public interest.
okay.
we have over 50,000 Vermont members and supporters, but anyway, thank you.
Thank you. I actually did have questions. So states have passed data protection, I'm sorry. So the student online privacy from 2020, we haven't talked much about that.
Yeah, people forget about it. I was refreshing myself. It was signed into law by the governor on March 5th, 2020. So you may recall a few days later.
Yeah, yeah.
Things happened
Oh,
in this
that,
country.
yeah.
So maybe it didn't get a ton of fanfare,
Yeah.
but
I
it's
don't think there was a causal relationship there.
no, but
Yeah.
in terms of it getting kind of
That was
lost in
good
the
point,
mix.
yes.
And it was modeled on California's SOPIPA law, and basically it deals with educational technology companies. So, things like, I don't even know if this is still what it's called, Google Classroom, technologies that people use in the educational setting, prohibiting any data that they're collecting on students, through those ed tech platforms, prohibiting them from using that data for anything other than educational purposes. So if you're collecting data that, a student is, struggling at math, you could not then use that for advertising purposes to try and advertise to students for math tutors or
Yeah.
something.
So that makes a lot of
Or
sense.
target, yeah.
Yeah, so maybe we can find out more about that too. But
Well, yeah.
do you have any information on how it's going? If there have been lawsuits?
That's, so again,
Maybe they changed their processes?
well, so it's, so the Attorney General has enforcement, so I think there'll be a question. I don't know if the Attorney General has brought, any actions under that law.
Mm-hmm.
And then it has a private right of action via the Consumer Protection Act. It's the boilerplate language of anybody who violates this law violates the Consumer Protection Act. And as you heard yesterday, that Consumer Protection Act private action, you have to prove actual damages. So again, this is a distinction, and why there probably have not been a lot of frivolous lawsuits under the regular Consumer Protection Act. Just demonstrating that, for instance, somebody, maybe misused, students' data, may not be enough to bring, a lawsuit there. You have to demonstrate, actual damages. But that recourse is available to consumers.
Okay.
So I'm not sure if any suits have been brought by that, but I can take a look. And like I said,
Well,
California's had a
I
lot
can ask
of books.
the
Yeah,
administration too, but that's really good to know. So
Yeah.
thank you. That's helpful.
yeah.
Yes.
Could you repeat your exact argument for why you think the private right of action is a good thing in this?
Sure. There's, a couple reasons. First and foremost, if a consumer let's just move forward and say that we want to enact a bill giving consumers privacy rights. We can debate what those rights are, but we want to give them rights in this bill. For instance, banning the sale of sensitive data. If a company violates that right, if they sell my sensitive data without, my permission, we believe that the consumer should have the ability to hold that company directly responsible by a suit for violating that right. If you give the Attorney General sole enforcement, you are removing that from the consumer. You are saying that only the Attorney General can bring action, which the Attorney General can and will, but as you heard yesterday, they can't bring action on behalf of consumers. They bring action on behalf of the state. So we believe that giving consumers the right, if we're going to give them rights, give them the ability essentially to hold those who violate those rights accountable. That's pretty, sort of basic concept. And the other reason, like we say, it ensures better compliance, we think. Something with like online privacy, and you heard in Matt's testimony, there could be a lot of violations out there. The Attorney General is only going to be able to bring action. I mean, the resources are not limitless. So having consumers have the ability to hold those who violate those rights accountable, we think gives us a better shot at people actually complying with the law and respecting folks' privacy.
Do you have other examples where laws that are currently on the books that do not have a private right of action are enforceable by the Attorney General, where there is not very good compliance? Because it's a longer argument.
Yeah.
there would be better compliance if there was private right of action, but do you have examples of laws and books to support your argument?
That's a fair question. I have to think and come back. So you heard the example yesterday, for instance, of the data breach notification act. That is something that is exclusively enforced by the Attorney General's office. It's a little bit hard, I would say, to measure non-compliance, because for something like that, I don't know if we just may not know who's not reporting data breaches. Like if they don't report it and a data breach happened, they may not be complying with the law. We don't know if they're complying with the law or not, right? So that's a hard thing to measure.
Respectfully, it sounds like your argument is kind of based on a hunch.
I would disagree, but
That's fine.
sorry.
I love your last name, though. Yeah, you're welcome.
Like
You can change
sound of
your
it,
name in this.
I appreciate hearing Sopitha for the first time in my life.
if you stick around the privacy world, you hear a lot of.
The first
A lot of
time, that was
inputs.
the first time I've heard that one.
That's funny. Well, thank you very much for all that you brought to us. All right, I'm gonna have to scoot out in a couple of minutes just to go to another committee, but the vice chair will keep things going.
Sure. So busy.
So next is Cody Bensky, Senior Policy Counsel at ACLU. Screen. Thank you. There you go. Okay. So we haven't actually introduced ourselves. So let's do
Come here,
that.
Russ Engel, Business District.
Sam Douglas, Woodlands County District.
And Rob Plunkett, Bennington.
Wendy Harrison, Wyndham District. And so let's just go around the room because we haven't done that.
I'm Thomas Weiss. I'm a citizen who's been encouraging stronger data privacy and data protection laws since 2018.
Josh Diamond, I'm an attorney with the Dinsey Law Firm. I'm special counsel to the Vermont Chamber of Commerce.
Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber.
Mary Hayden, Executive Director of the Vermont Association of Area Agencies on Aging.
Matt Schwartz, hi, Cody, nice to see you.
I see Matt.
Hi, I'm Drake Turner, working at Support Data Privacy.
My name is Emma Regan. I work for the Necrossin Group.
I'm Zach Amanelli. I work for VPER, Vermont Public Interest Research.
Great name.
Great name.
Jessica Barnard, Executive Director of the Vermont Medical Society.
Molly Mahar, President of Vermont Ski Area Association.
And I'm sure we can get you to testify.
Great.
Okay.
Thank you.
Okay, so Cody, the floor is yours. And please introduce yourself and give us your testimony. And please do send written testimony.
Excellent. You should have written testimony from me posted on the website. Chair Harrison and members of the committee, thank you for holding this hearing and inviting me to offer testimony on S71, the Vermont Data, Privacy, and Online Surveillance Act. I'm Cody Bensky, a senior policy counsel with the American Civil Liberties Union. I am testifying on behalf of the ACLU and the ACLU of Vermont. For more than 100 years, the ACLU and its 54 state affiliates have been among the nation's premier defenders of civil rights and civil liberties, including longstanding commitments to privacy rights and other rights like reproductive autonomy. Although doubtlessly a data privacy bill, S71 is an essential step forward to protect myriad rights underlying our constitutional system. S71 is a step toward a modern bulwark to ensure that the Fourth Amendment retains meaning in the digital age, that Vermonters' rights to reproductive and gender-affirming care are protected, and that undocumented people seeking refuge are not denied the right to seek asylum. These harms are not hypothetical. Instead, we are increasingly seeing the ways that our data may be used to undermine our fundamental rights. First, attacking healthcare, reproductive rights, and gender-affirming care. Last year, the Federal Trade Commission brought enforcement actions against a half dozen data brokers for not only selling location data, but marketing it as revealing visits to hospitals, oncology centers, and other medical centers. Our data can similarly reveal access to abortion or gender-affirming care. For example, reporting by 404 Media detailed how one data set shows a phone beginning the day in mid-June at a residence in Alabama, crossing state lines and visiting an abortion clinic for approximately 2 hours. Similarly, data collected by period trackers, fitness apps, or even brick and mortar retailers may provide a means of predicting someone's pregnancy status. Such data has been weaponized by anti-LGBTQ+ organizations or anti-abortion groups to target specific individuals revealed in the data. Second, tracking undocumented people. The federal government's deportation machine depends not only on invasive governmental technology, but private data brokers as well. For example, over the past 4 years, the data analytics company Palantir has received more than $1 billion from immigration enforcement agencies. Ventel, a provider of location data, had 7 contracts with ICE totaling at least $330,000 between 2018 and 2022. ICE and other agencies have similarly utilized databases from LexisNexis and Equifax to conduct millions of searches, including for information as seemingly benign as utility bills, to identify and track undocumented people. All this data is foundation for President Trump's deportation agenda. Third, undermining the Fourth Amendment. In addition to purchases by immigration agencies, other arms of the government have purchased our data from data brokers, all without a warrant or judicial oversight. For years now, federal agencies, including the Internal Revenue Service and the Department of Defense, have been buying their way around the Fourth Amendment by purchasing American sensitive information from data brokers. These companies often obtain this information through common applications like the Weather Channel or Tinder without users realizing it, and the government then uses that information to track people's location without a warrant or probable cause or even suspicion that anyone in the data set has done anything wrong. Finally, empowering the DOGE agenda. Since President Trump's inauguration, the so-called Department of Governmental Efficiency has sought to stymie programs that provide crucial and sometimes life-saving support to Americans. At the core of DOGE's strategy has been access to our data at the Internal Revenue Service, the Centers for Medicare and Medicaid Services, the Social Security Administration, and more. Ongoing litigation may ultimately end DOGE's access to federal data, but that may not be enough. Just as DHS and other agencies have ready access to the data broker market, DOGE too may be able to satisfy its hunger with privately held data that is just clicks away. Use and abuse of our information is about more than wonky technocratic debates over privacy policies and data practices. It is about real harms for real people. S71 will provide real, meaningful protections against these incursions. Several features of the bill mean that it will not be business as usual for big tech, data brokers, and those who profit off their surveillance. I will highlight 3. First is the universal opt-out. Nearly all state privacy bills purport to provide individuals with the ability to opt out of 3 data uses: the sale of data, targeted advertising, and profiling. However, as the Federal Trade Commission has emphasized, those opt-out rights are all too often illusory. In many cases, opt-out rights require navigating layers of settings, which can then be divided among multiple tabs with unclear and sometimes conflicting interactions among the options. This bill would not only prohibit such use of dark patterns, but it would give users a new tool in their toolbox: universal opt-out mechanisms, which are browser extensions or other technologies that automatically exercise opt-out rights as determined by the user. Second, robust data minimization. Data minimization means limiting the collection and use of our data to what is needed to provide the services we request. If you permit a mapping application to access your geolocation to provide directions, it will be prohibited from using that data to secretly identify what health clinics you have visited. If you provide bodily statistics to a fitness tracker, it will not sell those to a data broker. This provision is so essential because although many data harms stem from data brokers, that data must come from somewhere. In reality, it comes from the apps we use every day. Apps for weather, dating, shopping, games, and even levels and flashlights. Under this bill, Vermonters can be confident that the data they provide for important services is used only for those services. Third, shoring up existing anti-discrimination laws. Algorithms are increasingly used to help make decisions about us in areas that have long been protected by civil rights laws like housing, employment, credit, governmental benefits, healthcare, education, insurance, and more. Algorithmic systems can cause discriminatory outcomes propelled by data reflecting existing biases and disparities, misuse by users, deployment within discriminatory systems, or perhaps even just a poor fit between what the algorithm measures and its intended purpose. For example, tenant screening algorithms are prone to errors and often incorrectly match criminal or eviction records to people with similarly sounded names. Likewise, algorithmic resume screeners favor male candidates, are inaccessible to applicants with disabilities, and may discriminate against first-generation college students. S71 would provide needed stopgaps to ensure civil rights protections extend to this new technology. These fundamental protections are accompanied by other important features in S71, such as data rights, protections for sensitive data, and guardrails for health data. In many ways, S71 builds off efforts in other states and the lessons learned there. S71's universal opt-out rights closely follow mechanisms recognized in California, Colorado, Connecticut, Minnesota, Montana, and Maryland. Similarly, the data minimization provisions in this bill iterate on requirements passed in California and Maryland, and the anti-discrimination measures draw from Maryland and Minnesota. Crucially, however, S71 reflects the hardest lesson learned about other states' efforts. They simply do not work. Many states have replicated Virginia's approach to privacy, lean heavily on consumers to do the work, provide few guardrails, and enforce sparingly. Virginia's model perpetuates the fiction that we consent to data practices buried in dense, impenetrable privacy policies. Those laws leave us, the consumers, to individually police big tech and data brokers, filing data rights requests one by one with hundreds of companies that use and abuse our data. Meanwhile, tech companies can do what they like as long as their practices are disclosed to us. This is perhaps one of the few cases when sunlight is not the best disinfectant. Virginia-style laws have passed in, give or take, 17 states, and they have not reduced data abuses at all. The threats to healthcare, undocumented people, and Fourth Amendment rights still abound. What we need are guardrails, not empty promises, and S71's universal opt-out, data minimization, and anti-discrimination provisions provide those safeguards. Despite its many strengths, S71 is not perfect, and it is far from perfect from the perspective of the ACLU or the ACLU of Vermont. We will continue to refine provisions regarding heightened risk of harm to avoid potential First Amendment implications or abuse by enforcers. Similarly, as suggested by other folks here at the table, we would expand the private right of action and the scope of the bill's coverage. That said, the bill sponsors have clearly engaged with a wide range of stakeholders across advocacy and business. They have carefully crafted a bill that would make Vermont a leader in addressing harms while still enabling innovation and the services we depend on to speak, learn, run businesses, and connect. Thank you, and I look forward to your questions.
Thank you, Mr. Bensky. And Senator Douglas, do you have any questions for Mr. Bensky? I know you weren't here for part of it. No. But Mr. Bensky, did you hear Mr. Douglas's question from before regarding the private right of action?
I believe so, but if you could restate it, that'd be helpful.
My question was for Peter. I wasn't asked if they said. I know. So I believe the question was essentially argument, not ACLU's argument. I will ask it myself then, Mr. Bensky. I'll do it afterwards. Do you have any other questions, Senator Douglas? Senator Engels, any questions? And Senator Amir was closed. No, I thought the cafeteria thing.
I will say on the private right of action, one of the best pieces of evidence for the fact that people ought to have the capacity to be able to enforce their own privacy rights is the fact that, as has been discussed, all other states have not provided private right of action. And the only place where we have seen really meaningful enforcement against big tech, against targeted advertising, have been in states where they have established specialized privacy agencies. California has that luxury with the resources provided to it. Other states do not. And consequently, we've not seen attorney generals with their many demands that have been placed on them bring any privacy actions. Texas may be the only other exception that comes to mind. I will note, that has been reflected, I think, in advice repeatedly provided by Vermont's own attorney general, as this body has considered this issue, often advocating for a private right of action to supplement attorney general enforcement.
And thank you, Mr. Bensky. I'm not going to do any follow-up on that. So we'll move on. I believe the agenda hasn't changed from what we have here. It hasn't. Not hearing that it has. So Christina, is it pronounced Glabus?
Yes, you got it right. That's maybe one of the first time.
Welcome, and the floor is yours.
Great. Thank you so much. Chair Harrison, members of the committee, thank you deeply for the opportunity to testify today. My name is Christina Glabus, and I'm the owner and founder of Gazelle Consulting, a HIPAA-focused data privacy and security firm out of Portland, Oregon since 2015. I'm here to testify in support of S71. I've served as a HIPAA expert for Oregon DOJ's Consumer Privacy Task Force, contributing directly to consumer privacy legislation, including a COVID contact tracing bill, the data broker bill, and Oregon's Consumer Privacy Act, which went into effect in 2024. My professional background includes consulting extensively with healthcare entities, nonprofits, and technology companies, particularly on compliance related to behavioral health and organizations with complex regulatory obligations, like if they have to do SOC 2 and HIPAA, or HIPAA and GDPR. While I got my degrees in psychology and human development, I followed the same path that many folks with psych degrees do. I went into tech. It's been very fruitful to bring those two perspectives together, but it's become very frightening to me because I see what's happening to people's minds from a different lens than most technologists. On February 26th, 2025, Instagram Reels, which is Instagram's TikTok equivalent that just sends you a feed of, 10-second videos over and over and over, suggested content, was inundated with explicit, violent, and torturous content of the most soul-crushing kind imaginable. For hours, if not multiple days, all over the globe, millions of children worldwide were exposed to a never-ending stream of horrific video content, including an elephant stomping a man in half. That went viral on Instagram because apparently nobody could look away. This terrible incident, a global trauma event, vividly demonstrates the vulnerabilities inherent in our current digital platforms. This was not a minor glitch. This was a systematic failure of catastrophic proportions, a digital disaster exposing millions, maybe billions of people, including vulnerable children, to deeply traumatizing suggested content, including rape, torture, murder, and animal abuse. A failure of this scale demands more than regretful statements from tech companies. It demands accountability and immediate legislative action. I grieve for the children exposed to this. As someone who lies awake at night worrying about the vulnerable minds of children on the internet, this is my worst nightmare. This troubling event serves as a stark reminder that digital safety must be addressed with the same seriousness and urgency as physical safety. Such failures profoundly impact the psychological well-being of our society, especially for younger users who are still in the developmental stages of their lives, where these kind of incidents can leave wounds that last a lifetime. If a system cannot be trusted to protect its users, then users, especially children, should have the right to opt out entirely. Their data should not be used to fuel an engine that turns their trauma into engagement metrics. Given Vermont's long-standing commitment to child welfare, it is critical that digital safety measures explicitly prioritize the protections of minors. Effective age verification and explicit parental content and the right to opt out are essential components of safeguarding young Vermonters from exposure to harmful digital content. I don't often find myself praising the lawmakers in Southern conservative states, but I reflect on those that banned social media apps for children this year. They gave the children in their states a profound gift of protection. This is a reminder that data privacy protection has bipartisan support. Vermont has long prioritized the maintenance and improvement of physical infrastructure, recognizing those as vital to community well-being and safety. Digital privacy warrants equal prioritization as it has become foundational to our digital lives. By proactively guiding businesses on how to ethically steward data and establishing robust standards for digital infrastructure, Vermont can protect residents from exploitation and systemic privacy failures, ensuring a resilient digital future. No Vermonter should have to choose between participating in modern life and protecting their own privacy. That's not a fair trade-off. That is coercion. I believe private right of action will also give Vermonters the opportunity to give businesses the feedback that they need. The Attorney General's office does not have time to give that kind of feedback, and we are all growing and evolving into this digital environment. Give consumers the opportunity to communicate and contribute and shape this. It is important to recognize that Vermonters' personal data generates significant economic benefits for corporations without corresponding benefits or adequate protections for consumers themselves. The economic imbalance calls for strong privacy protections to halt unchecked monetization of personalized information. Personal data fuels a billion-dollar economy, and the people generating that value receive no protections in return. Vermonters are not some sort of unfeeling resource to be exploited. These are people, children, the elderly, your family members, you. Strong privacy standards will help rectify the current unfair economic landscape and ensure ethical treatment of Vermonters' data. Transparency is fundamental to maintaining and restoring public trust, especially following significant privacy incidents. Businesses must be legally required to communicate clearly about data collection, breaches, and prevention strategies. In addition, robust and enforceable accountability standards must be established to address corporate negligence and to safeguard citizens from digital harm. Through my professional experience consulting on HIPAA compliance, I have observed considerable gaps in existing regulatory frameworks. I echo Zachary's concern about gaps in consumer coverage and have heard from the consumers themselves that they are confused and surprised and find out they don't always have coverage for their health data. They have told me that they find that to be un-American. HIPAA currently applies only to health information directly linked to insurance transactions, leaving sensitive data related to social determinants of health, such as housing and food security, largely unprotected. This regulatory gap creates confusions for organizations who are trying to do the right thing and risk for covered or uncovered organizations and healthcare entities alike. The idea that sensitive health-related data is only protected when linked to an insurance transaction is outdated and dangerous. In reality, personal health data extends far beyond the doctor's offices and insurance claims. If we fail to protect it, we are actively exposing the most vulnerable members of our community to harm. This bill avoids overly broad entity-level exemptions for HIPAA. It only exempts data that meets the criteria of PHI and is covered by HIPAA, which is already covered and protected by HIPAA. It only exempts that data. This approach cures this gap and provides clarity to organizations on the burgeoning edge of our society's healthcare needs. And for the record, generally healthcare clinics and doctors' offices do not have coffee shops and gift shops that would require them to comply with both HIPAA and consumer privacy laws. Hospitals do, because they are massive vertically integrated institutions. And when you make the decision that decision as a business to extend into new industries, that comes with additional legal obligations and complexity. That was their choice as a business, and Vermonters should not have to bear those costs. Vermont urgently needs comprehensive privacy protections through state-level consumer privacy law. It is critical that cybersecurity responsibilities are distributed clearly among all entities handling consumer data, and Vermont must avoid broad entity-level exemptions that risk undermining protection of consumer rights. The time for debate has passed. The harm is no longer hypothetical. The need for action is immediate. We are at a critical moment in history, and we may not have this opportunity to make this change again. I urge you to check in with your heart and check in with your children and do what both conservatives and liberal states have done. Please do what's right and enact consumer data privacy protection for citizens in Vermont now. Thank you.
Thank you. And Senator Ingalls, any questions? Senator Mason?
Nope.
Senator Douglas, any questions? I don't have any questions either. So thank you very much for your testimony.
Thank you.
And before Chair Harrison left, it sounded like another person who's in the room whose name I don't remember from the Ski Association was going to testify.
Yeah, I can today or tomorrow.
Okay, she was talking about tomorrow, or was she talking about today?
I don't know.
That's the part I think was.
She's on it tomorrow too, I think.
She's on tomorrow.
Yes.
Okay. So that brings us to the end of the agenda, unless it's clear from you guys that you're gonna amend the agenda. I think we will adjourn session for.
Can I just read, we have some testimony, unless you guys want to read it, but it's on the Vermont Country Store. They put some written testimony on that.
Sure.
We want to put that on the record on the air, or we just want to say it's on our website?
I will leave it to however you want to do it.
Well, I'm gonna just kind of read it then, if you don't mind.
Yeah, please do.
Testimony of Jim Hall, President and CEO of the Vermont Country Store. S71, act related to consumer privacy and online surveillance, Senate Institutions Committee, submitted March 12, 2025. As the president and CEO of the Vermont Country Store, a leading family-owned retail business based in Vermont, I'm respectfully submitting testimony for the record about S71, an act related to consumer privacy and online surveillance. Founded nearly 80 years ago, the Vermont Country Store was family-owned and run entirely in Vermont with operations spanning 4 counties, Bennington, Wyndham, Windsor, and Rutland. They occupy 6 facilities. We have retail stores located in Weston and Rockingham, as well as liquidation outlets that operate in Rutland's historic Armory building. The majority of our customer service teams members work remotely throughout Vermont. We have on-site call centers in our Rutland location and our Manchester administrative office building. Our largest presence is the Airport Industrial Park in North Clarington, where we own over 40 combined acres between 2 buildings with over 200,000 square feet. These facilities support our warehousing, order fulfillment, bakery, and manufacturing operations. We are a major employer in Vermont with over 450 employees and nearly 400 more working for us seasonally to support our peak fall foliage and Christmas seasons. We work hard, do right by our customers, and have a strong history as strong supporters of the communities where our employees live and work. We serve our customers throughout our stores, which are among Vermont's most popular tourist attractions, our nationally distributed catalog, and our websites, which accounts for the majority of our sales. Because online sales are fundamental to our continued success and future growth, we support consumer data privacy legislation that have been actively doing so at the federal level since 2021. However, we are extremely concerned about the significant risk of harm that S71 would have on our business. Ambiguous language throughout the bill makes compliance open to legal interpretation rather than limiting enforcement actions by the Attorney General. The inclusion of a private right of action provision invites opportunistic lawsuits by unscrupulous attorneys where business models are to drive settlements for their own financial gain rather than to achieve regulatory compliance. We have been the target of numerous legal actions originating in other states pertaining to product labeling and taxation and other laws that contain similar ambiguous language. We receive an ongoing stream of demand letters, legal notices, or intent to file and or filings, which are all intended to shake us down for settlement fees. The legal fees incurred to manage and settle these claims are exorbitant. It is imperative for Vermont to prevent this situation from occurring in consumer data privacy legislation. There's another approach that works for consumers and for business. S93, currently in the Senate Economic Development Committees, which secures strong consumer data privacy protections while being acceptable to Vermont businesses. The bill is modeled after Connecticut's data privacy statute and is consistent with New Hampshire and Rhode Island, creating a regional standard. Like S71, S93 includes strong consumer protection. Private right of action is precluded. Enforcement of the law would be handled by the Vermont Attorney General. The combined effect of both pro-consumer and is both pro-consumer and fair to businesses. Vermont Country Store operates in a highly competitive marketplace where we are much smaller than most of our competitors in the catalog industry. Significant increases in core operating costs for paper, printing, postage, and shipping have made it increasingly difficult to make catalog mailings profitable. We are pivoted to digital advertising as the most cost-effective ways to sustain and grow our business. But our future is by no means assured. In the past 2 years, a number of our competitors have either gone through bankruptcy or gone out of business. The following catalogs titles are examples you may be familiar with: Acorn, Signals, Babbitt Blue, Harriet Carter, Carol Wright's Gift, Dr. Leonard's, and Healthy Living all went bankrupt, resulting in significant job losses and were subsequently absorbed by other competitors. Understanding the environment in which we operate, you can see why it's critical that we prevent exposure to high expense costs in areas that are not supporting our future growth and success. I ask you to take this opportunity to support a data privacy statute that can protect Vermonters without harming the Vermont Country Store and the 450 families whose livelihoods depend on our business. Thank you.
And thank you, Senator Echols. I was able to speak with Mr. Hall the other day. It was a good conversation. I was hoping he'd be actually testifying.
But you've had some hardships. Yeah, a lot of people have.
Since he submitted this, I assume that won't be happening. I had not heard of any of those catalogs, but my mother was very happy to hear that Vermont Country Store bought Country Curtains and teaching in business. And so then without that, I think we will adjourn.